This program is brought to you by Emory University.
Okay, I hope everyone had a good break and enjoyed the consumer panel this morning. I know I did. This year at our 17th Annual Symposium, I'm excited to introduce our wonderful keynote speaker. We are very lucky to hear from Chief Judge Hagenow today. The Honorable Wendy Hagenow is the Chief Judge of the Northern District of Georgia. Chief Judge Hagenow assumed the bench on May 25th, 2010, and became Chief Judge on October 1st, 2017. Prior to her appointment, she was a partner at Bryan Cave Powell Goldstein in Atlanta, which is a combination between Powell Goldstein and Bryan Cave. Chief Judge Hagenow graduated from Duke University Law School with honors in 1983. Chief Judge Hagenow is a native of Memphis, Tennessee, and received her bachelor's with highest honors from the University of Tennessee, Knoxville in 1980. Chief Judge Hagenow has served in numerous leadership positions in the community, including as an advisory board member for our journal, as well as the treasurer and director of the Southeastern Bankruptcy Law Institute. It is my great honor and distinct privilege to introduce Chief Judge Hagenow, and I hope you all join me in welcoming her. Chief Judge Hagenow.
Well, good morning, and thank you. Thank you so much for inviting me to speak here. As you mentioned, I have been involved with the Emory Bankruptcy Development's Law Journal Symposium for quite a while. I was on the advisory board for a number of years before I went on the bench. The symposium always does such a great job of coming up with good topics and bringing really fascinating speakers, so I'm thrilled to be part of your process today. So I was asked to speak a little bit about my background, the evolution of the bankruptcy law since I've been practicing bankruptcy law, and where I think bankruptcy law is going or where I think it should go. So here goes. So my first exposure to bankruptcy law was the summer after my first year in law school. I worked for a sole practitioner in Durham, North Carolina, and among the other things she did, she was a Chapter 7 trustee. So this was 1981. Remember, the Bankruptcy Code was enacted in 1978. So it's still relatively new, and I remember being with her and being around the other attorneys who were still confusing the terms referee and judge, and they were still trying to figure out what some of the provisions of the Bankruptcy Code meant. So that was my first exposure to the bankruptcy law. When I came out of law school in 1983, I joined a small law firm, and a number of the lawyers there that I worked for either had been trustees or had represented trustees, like representing Judge Bonifeld before he was a judge. And so I continued my contact with the bankruptcy world, mostly representing creditors at that point. But I will say, and anybody who either has worked in a small law firm or if any of you law students do, you will find that you'll do whatever comes in the door, right? You don't pigeonhole yourself quite as much as you might have to in a large firm. So one of the things I did quite a bit of was healthcare law. At the time, we had quite a healthcare practice. We represented Northside Hospital and a number of other small firms, small hospitals. So I was out there doing medical malpractice defense and staff privileges and medical records and certificate of need and all this healthcare stuff, as well as general litigation, as well as bankruptcy. But in 1988, our small firm merged into Powell Goldstein, which at the time was one of the larger firms in Atlanta. And initially, I still kept my dual practice of healthcare-related work and bankruptcy-related work, but eventually you had to choose one, and I chose bankruptcy law. But have no fear, I used my healthcare practice when in the late 90s and early 2000s, we had quite the rash of nursing home bankruptcies that I was involved in. And it really helped that I could speak the language, at least as to some of the basic concepts in the healthcare area. The lesson for law students here is take every advantage that's offered to you, even if it doesn't seem to be in the area that you think you want to practice in, because you never know when it will come back and you will have some useful bit of knowledge that will help you in your practice. Now, I chose bankruptcy law when I had to choose between the two areas. I chose it for a number of reasons. First, I really, really liked the way that bankruptcy law was a combination of a litigation practice and a transactional practice. I also appreciated that the bankruptcy practice and bankruptcy practitioners were very practical in their approach to the law. I liked the fact that the bar in Atlanta was really relatively small. You really got to know each other because you worked with each other over and over again in the cases, and you found ways to work collaboratively. And finally, it became obvious to me, and even more so later, that bankruptcy law is something that we really need in our country and in society. So let me think about the law students for a minute. As you're interviewing for jobs, probably the number one question you get asked is, well, so are you on the litigation side or are you on the transactional side? What kind of practice are you interested in? And when I came out of law school, I gravitated toward the litigation side. I was a political science major, didn't really have much of a business background. So I went the litigation route. But once I started working in the bankruptcy law, it just opened up this whole new world to me. I learned about corporate law more, I learned about negotiation, and you actually have an opportunity to use these skills so often in bankruptcy. Everything that happens in a bankruptcy case requires notice and a hearing. Think of all the opportunities you have to resolve whatever that issue is if someone's going to object. And as a young associate, it's fabulous because some of those things are small and they will send you out to take care of those items. Not everything is major, and there's lots of opportunities for young lawyers. I also worked with some great lawyers who taught me things like municipal bond transactions, how to read a real estate contract, how to draft various corporate documents. And so with each new case I worked on, I learned something new. I learned about environmental law. It's just amazing the things that, the doors that opened up to me. And I have found that to be true, and it's also true for consumer lawyers, right? You have to know some corporate law. You have to know tax law. You may have to know some domestic relations law. You may need some employment law. And of course, you need real estate and contract law. So bankruptcy is really varied. A lot of people say that bankruptcy is the last great general practice because of the number of areas that you have to at least know something about. I tend to think of it as a law school exam, where every case that opens up before you has a little bit of everything in it, and you have to identify it, and then you have to figure out how to solve each of those problems. Now, as I said, I really like the bankruptcy bar, too. Again, knowing everybody makes it much easier to solve your cases and to try to work out solutions. But it also meant that you better not be unreasonable in your demands, because most certainly what goes around comes around. If you don't give someone an extension of time, you can pretty much bet you're not going to get one when you ask for it. And I frequently had a very different experience if I was practicing in what I would call a general litigation court, where the bar was so large they didn't have that personal feel. So I just really liked the smallness of the Georgia bar. The other thing that was great about practicing bankruptcy law and seeing the same people over and over again was you saw people that you aspired to be, right? You were watching people that were senior to you, and you were seeing what they were doing and what they had learned and where they went. So even if they weren't in your firm, you could say, well, that's what I want to do. That's what I want to learn. That's where I want to go. And so I think the bankruptcy bar was really a great place for me. I also appreciate the fact that the bankruptcy practice is more practical. And let's think about that for a minute. If you have a bankruptcy setting, everybody involved is short of money, right? The debtor, by definition, doesn't have enough money because they're not paying their debts as they come due. And the creditors have already lost some money somehow, right? There's some obligation that's in default that the creditor holds. And even a bank that may have a, quote, ton of money, they've lost money on this transaction. So everybody's pretty focused on not throwing good money after bad. And what I found is that folks kind of, they staked out their positions maybe at the outside of their legal positions, but pretty quickly everybody's looking for the practical solution. And it may take a while to get there, to find the solution to all the pieces of the puzzle, but everybody's generally looking for the solution. There's very little litigation on principle in bankruptcy, except perhaps in the area of discharge and dischargeability in the consumer world. So I really liked that. Now, when I started practicing, bankruptcy practice was also practical because it was very local, right? So all the creditors were based in Atlanta. You had C&S Bank, you had First Atlanta, you had National Bank of Georgia. And what would happen there is the lending officer was usually still at that bank because people didn't change jobs very often back then either. So the lending officer's still at the bank. The lending officer probably still knows the principal of the debtor, the corporate debtor in default, or knows the individual debtor. And imagine the difference of collection techniques and of litigation and negotiation when you all know each other and you all live together. So it was a different environment at that time. I also liked bankruptcy law, as I said, because I feel like it's very important, and it's something that our society has to have. And we've heard some of that this morning from the consumer perspective and how important it is perhaps for the economy to discharge debt and let debtors go back and borrow more and keep our economy going. But I think it's important for another reason. When I was sworn into the bench, Judge Edmonds of the 11th Circuit was the judge who swore me in, and he gave his theory of why bankruptcy law was so necessary. And some of you may have heard this before, but I think it's worth repeating. It was his view that our forefathers came to America, at least in part, to escape debtor prison. After all, if the penalty for failure is going to jail, how entrepreneurial will you be? How many times will somebody take a risk if the downside is you're going to jail? I've often thought it's pretty remarkable that when the Constitution was being drafted, and these really smart people are thinking about things to set up a government for the first time, one of the things that was important to them is that we have to have uniform laws of bankruptcy. Maybe pondered that for a minute, that in all the things they're dealing with, bankruptcy was that important to them. And so I think Judge Edmonds was right. He says, look, our original settlers in our country could only work if the people who came here were empowered to start new businesses, invent some new widget, or come up with some new idea. And in order for that to work, there had to be an organized and uniform system of winding it down that didn't penalize you as long as you were honest in your attempts. Think the number of times we hear the honest but unfortunate debtor, right? That's the idea. If you were honest but you just didn't succeed, you're not being punished. We're just going to wind it up in some really organized way and let you try again. You know, I suspect if you survey the history, particularly of businesses, you will find many businesses in this country that were born of and from a bankrupt business. So one example that came to my mind as I was putting this together is when I came to Atlanta in 1983, there was virtually nothing in Midtown Atlanta, and it was not really a desirable place to be. But Colony Square was out there. Some developers had foreseen, even 10 years earlier, that Midtown was going to be the next great place for Atlanta to develop. And so they plopped Colony Square out there at 14th Street and Peachtree. And it took at least 2 bankruptcies, maybe more, before Colony Square actually took off, before the rest of Atlanta caught up with them. Now, the ownership may have changed, but the building never shut down. The building is there, it's successful, but you had to have the process, the bankruptcy process, that allowed one ownership to transfer to another ownership, or to pay off one lender and get another lender in. I also think it's important when you think about bankruptcy to recognize that the Bankruptcy Court is the federal court most likely to come in contact with U.S. citizens or U.S. residents. And think about that for a minute. They may be debtors, they may be creditors, they may be employees of a bankrupt corporation. They may be employers of our individual debtors who have to withhold money every paycheck and send it into the Chapter 13 trustee. But more people come in contact with the Bankruptcy Court than any other federal court. And I think it's really important at all times, but particularly in light of the way courts sometimes are portrayed today on TV and other places, that we recognize the significance of our court and that all of us as participants in the court relay to the others who were there that we are a fair court, we do justice, we do listen, and we try to follow the law and do the right thing. So what do I think the future holds? Well, I hope the future holds a lot of what I've loved about the practice. I hope parties will continue to resolve most of their disputes instead of litigating most of their disputes. The Bankruptcy Code, when it was enacted, was actually set up as a framework within which negotiation could occur. And it was frequently described, and where's Rich Levin? He'll probably agree with me. It was originally set up to be sort of a 3-legged stool, right? With the idea being that the legs were actually equal lengths between the debtor, the secured creditor, and the unsecured creditor. Everybody had a role to play. Now, as time has gone on, the code has been amended, lending practices have changed. I'm not sure our 3 legs are the same length anymore, right? Most corporate debtors that come in, all their assets are leaned up to their secured lender, so there's frequently not much an unsecured creditor can argue about, and many debtors don't even have much leverage by the time they get in there. So I think that's going to continue to evolve and continue to change the bankruptcy practice. I do think the bankruptcy bar will continue to be a smaller, tighter-knit bar than the bar in general, but I think it will not just be local. It will be more regional or international or national, depending on the type of practice that you have. But if you have a national practice, you will continue to run into the same people over and over again, and they will know how you practice, and they will count on your integrity as a lawyer as you move forward. And judges that you appear before in other courts will do the same. But there is one thing that I hope will change, and I hope you all will take this to heart, and that is that we need our bankruptcy bar to be more diverse. And by diversity, I mean in every respect: race, sex, gender, nationality, but also just diversity of background and experience, right? After all, debtors are diverse. They come from all walks of life. They're in all types of businesses, and they deserve representation that understands them, their backgrounds, their business challenges, their business models, and they deserve judges that are diverse and have had different experiences as well. So what I hope will happen is that the bankruptcy bar of today will make a real effort to bring in graduates that are interested in bankruptcy law, that have very diverse backgrounds, teach them, support them, so that they can be our leaders in the future and ultimately our judges. Now, one thing that has changed in the bankruptcy practice already, and will continue to change, is that it's not a local practice anymore, right? There's no CNS Bank, there's no First Atlanta. In every case, including consumer cases, the creditors are national, and many times the debtor has business all over the country as well. We also have an international aspect to many businesses now, and we have a world economic system where things happen in one part of the world and affect us here in the United States. A couple of things just to ponder. Do you think anyone anticipated, when they came up with the idea of securitization, the number of people that would lose their homes in Atlanta in 2007, 8, 9, 10? And you know, the people that lost their homes here were not all the subprime borrowers of the loans that were securitized. They were the bankers who made the loans when the bank, and then the bank shut down. They were people that worked in the lumber yards. They were construction workers. They were appraisers. So there's a real ripple effect when your economy is as connected as ours is. Same is true when you had the GM failure. It isn't just the employees of GM that felt it. It was the employees of suppliers to GM. And guess what? When employees either get laid off or they feel insecure about their job, they don't go to the movie theater. They don't go to the dry cleaners as often. They spend less at the grocery store. And so then those small businesses begin to feel the impact as well. And more recently, we have the coronavirus in China. And we've been told that there may be fewer Apple phones for a while, and Apple's profits may go down. But there was a report just last week of a company called Valeritas Holdings. It's a drug technology company, filed their Chapter 11, and they attributed it to the coronavirus and the fact that they couldn't get supplies out of China. So if you think for just a minute that coronavirus in a province in China causes a company in the United States to fail, you know how intertwined we are. And I think that's going to take some adaptation to the law, as well as adaptation by the lawyers to figure out how to address it. Now, there have been some changes in the bankruptcy law and I think they're good. They're looking for ways to address particular situations. There's a recognition, I think, now that Chapter 11 is not a one-size-fits-all. We had the Small Business Reorganization Act go into effect yesterday. We have not yet had one, I don't believe, but it did go into effect yesterday, and that will be very helpful to the smallest of the businesses. We do have special provisions for family farms and family fishermen. We have some provisions for municipalities, not in Georgia, but we do have those, and we have provisions for international business. But I think we'll see further development in the law as you recognize that the primary provisions of Chapter 11 do not fit every single situation. But lastly, I will say I do think that bankruptcy will continue to be critical to our country. Again, let's think the coronavirus. You know, you want a business to be responsible, right? And you want them to plan and anticipate where there could be problems. But who in the United States can anticipate the coronavirus in China and plan for the interruption of their supply? So we're going to need the bankruptcy code. We're going to need the automatic stay. So companies where something that happens in another part of the world suddenly triggers a problem for them, they need the protection of bankruptcy to figure out how best to work out of it. And of course, we've heard already today why we think it's important for the continuation on the consumer side. So anyway, I hope you all find the bankruptcy law as rewarding and interesting and challenging as I did, and I have. I mean, it is a changing, dynamic area. And one thing I can say for sure is that there's never a dull moment. Thank you.
All right, before we get started on the corporate panel, I want to say a quick thank you to Chief Judge Hagenow. That was such an inspiring speech and really put in the perspective of just how large the scope of bankruptcy is. Many consider it to be a niche practice, but all of us in this room realize that now, it's not so niche, it's actually global, and it is very impactful throughout the world. Now, without further ado, I'd like to bring to the stage our corporate panel. So please make your way on up here. And I would like to quickly introduce the moderator for this panel. It is Sarah Borders. She is a partner at King & Spalding. She is a true champion of the corporate bankruptcy world, not only just in Atlanta, but throughout the country. So we are very honored to have her here today and to moderate this excellent panel who we believe are some of the best minds in the field. Thank you all again and enjoy the corporate panel.
Thank you so much. So we'll get started. I was in preparing the very brief introductions. I thought to myself I could take up the full hour and 20 minutes simply introducing the panel, but I will keep it short. Immediately to my left is Professor Bruce Markell. Professor Markell is the professor of bankruptcy law at Northwestern, where he has been since 2015. Prior to his tenure there, he has been, among other things, Judge Markell. He was a United States bankruptcy judge for the District of Nevada. He's been a practicing... Nevada, thank you, Nevada. He's been a practicing lawyer. He practiced for more than 10 years and was a partner at Sidley & Austin in LA, and was a law professor at a number of additional universities. To Professor Markell's left is Rich Levin. Rich Levin literally wrote the United States Bankruptcy Code in the late 1970s. As the assistant counsel to the House Judiciary Committee, he was a driving force behind the code as we know it today. He's had a lifetime commitment to bankruptcy legislation, to the process and its application. He's currently the co-chair of Jenner & Block's Restructuring and Bankruptcy Department, where he advises clients in their most complex restructuring matters. To Rich's left is Professor David Skill. David is the S. Samuel Ash, you'll have to correct me, Arsht, Professor of Corporate Law at the University of Pennsylvania Law School. After a brief stint in private practice, Professor Skill taught at Temple University before joining the faculty at Penn. His book, Debt's Dominion, A History of Bankruptcy Law in America, is one of the best explanations available of how we got where we are today with debt in bankruptcy. I recommended it to my daughter, who is a law student, and I recommend it to you. Among other things, in 2016, Professor Skill was appointed by President Obama to the Financial Oversight and Management Board for the Commonwealth of Puerto Rico and is one of 7 members responsible for the financial reorganization of the Commonwealth. And then finally, Professor Doug Baird. Professor Doug Baird is perhaps the leading author, speaker, and thinker in the field of bankruptcy. If Wikipedia is correct, he's written more than 13 books and 71 articles.
He wrote the Wikipedia.
There you go. His textbooks on bankruptcy are used in law schools around the country and have provided an introduction to and foundation for bankruptcy law for generations of young lawyers. Professor Baird currently is the Harry A. Bigelow Distinguished Service Professor at the University of Chicago Law School, where he also formerly served as the Dean of the Law School. Among other things, he's the recipient of the 2008 Emory Bankruptcy Development Journal's Distinguished Service Award. So that is our panel. My moderating duties might be almost over if this goes as I expect it will. So I'm going to pivot to Professor Baird to lay out the premise for our discussion today.
And thank you very much. It's really, awe-inspiring to be on a panel like this. What I've been asked to do is to say a few words about the essay that I wrote for the journal, which grows out of a larger project I've done that tries to follow in the steps of David Skeel and retrace the evolution of corporate reorganizations. And what I've done in re-examining this arc is looked at more closely the way in which fraudulent conveyance law has really influenced the shape of reorganization law. And it's not that surprising. Fraudulent conveyance law really has given shape to much of modern commercial law, and Twine's case is still the focal point. It's one of the few cases from the early 17th century that lawyers still talk about. And before I continue, something I should say is there's a new piece out by Emily Edmonds, which is absolutely brilliant. She's probably our best commercial legal historian, in which she has gone back and looked at the record of Twine's case, because it was done in the Star Chamber. All the records still exist if you can read the handwriting, which I can't. And she's gone through all the depositions and everything, and it turns out that the case is actually quite different than the common account. Among other things, in my essay, I got the year wrong. It was 1602. It turns out the riot started when the sheriff was seizing cattle, not sheep. But there are a lot of other things that just make this sort of required reading for everyone. But at any rate, modern fraudulent...
Let me just interject at one point. It's not out yet. I actually have intimate knowledge of the article.
No. But it will be out.
Well, I won't say about the author, but she is my wife. It's currently in edit. It probably won't be out till mid-year. But when you do it, it's in print. It was 94 pages and 604 footnotes. So have fun. But it reads like a novel. It really does. It'll be in the American Bankruptcy Law Journal.
No, it's again, required reading. At any rate, where's modern fraudulent conveyance law today? Well, the two things we know about is we're used to 548 and its equivalents and the evolution of this idea of hinder, delay, and defraud, and how that now affects all sorts of activities, because the test has morphed into constructive fraudulent conveyances, and we look at insolvency and transfers for less than reasonably equivalent value. And again, it's old familiar stuff to all of us. Also, it decisively shaped the way in which preference law emerged. Preference law emerged in the late 18th century out of fraudulent conveyance law. Originally, it was called a fraudulent preference, and then preferences took on a life of their own.
I'll disagree with you on that one, but read my article first.
Okay, I think this is going more slowly than I expected.
You knew better than that.
Henry, less...
We only promised you 3 minutes.
Right. So, Henry, less noted, and though I should say, Bruce has an article in the early 90s where he does talk about this, but not commonly noted, is that fraudulent conveyance law in the late 18th, early 19th century also gave rise to a number of judicial opinions in which judges reviewed things like assignments for the benefit of creditors, of foreclosures, or virtually any transaction where you had an interaction between a debtor and some creditors that potentially put other creditors at a disadvantage. Not because bankruptcy was on the horizon. This is an era when, by and large, there wasn't bankruptcy law. Not because there was a preference, but simply judges would look at the process. Unlike modern fraudulent conveyance law, they weren't looking at discrete transfers. They were simply looking at the transaction as a whole and saying, wait a second, is this a transaction that has badges of fraud? Is this a transaction that is defeating the rights of creditors in a way that's inappropriate? And this led, by the middle of the 19th century, to judicial review of railroad foreclosures and reorganizations. And the iconic case here, which should be a lot better known than it is a case called Howard. And the essential dynamic here, which we've seen a lot of times before, is we have a railroad that's hopelessly insolvent. We have a senior creditor. The senior creditor wants to get the railroad. And the people in control of the railroad say, well, you can do this the hard way or the easy way. You know, the hard way is you can pursue American justice. Okay? The easy way is I'll cave in and just give everything to you. Provided, of course, you leave a little bit for me on the side. You give me a little sweetener. And the Supreme Court had very little difficulty striking that down and saying, no, that's not good. This kind of deal in which the senior creditors do fine, the old shareholders get something, and the general creditors are wiped out, that's not something that's acceptable. That violates fraudulent conveyance principles. These transactions have badges of fraud. Okay? Now, not that surprising given what came before. The problem that this created is, what about your ordinary railroad executive equity receivership, which has much the same characteristic. In form, you have a secured creditor bidding at a foreclosure sale, and then there's a set of negotiations, and the people who were sitting at the bargaining table will figure out how to divide up the company, and part of the value of the company is going to go to the old shareholders. And the question is this okay? Does this transaction have fraudulent conveyance problems? One of the principal lawyers involved during this period was Rich's partner, and this
Former partner.
you're Jenner now, so yeah. So anyway, but Rich's partner, his attitude was, badges, there are no stinking badges. There's no fraudulent conveyance here. Move on. Everything is just fine. And he and other lawyers of the era pushed back against this characterization. And his attitude was, as long as it's done
Wisely and successfully, I might add.
Sorry?
Wisely and successfully.
Well,
Mostly
you're half right.
mostly unsuccessfully. He retired early, but that's a different story. But basically what happened. Yeah, but basically what happened was that there was pushback against this idea in the Supreme Court, and ultimately the Supreme Court came down with cases like Boyd, in which Boyd said, you can't exclude people. There has to be a fair process. Everyone has to be able to come to the bargaining table. Everyone's entitled to a seat at the table. And that was what emerged out of this dynamic. And the claim I would make is that dynamic is still very much with us. Now, again, there are changes. In the 1930s, there was an aggressive intrusion of the judge into the bankruptcy process. And the idea of the New Deal reformers is judges really need to be very heavily involved. And that was pushed back, as we've discussed in the earlier panel, in 1970s, and quite properly, the judge is no longer someone who's actively involved in the administration of the case. Nevertheless, the judge still has oversight. The judge is still supposed to look out for the integrity of the process. The question that I want to focus on and direct the other people to, and the claim I basically want to make is that the takeaway from this is that when we look at new cutting-edge problems in corporate reorganizations, whether it's critical vendor orders or rights offerings or backstops or roll-ups or these other types of issues, you shouldn't necessarily gravitate immediately towards some particular statutory hook, because Rich is really, really smart, but he didn't foresee roll-ups, rights offerings, backstops, and things like that in 1978. Critical vendors. Again, I don't want to go on too long, Rich, but still, it's the only
thing we foresaw was that in 40 years the world would change. We didn't know how.
Yeah, but I think the takeaway is you don't look for specific statutory hooks in the first instance. You don't sort of go back to old saws like, absolute priority and pro rata distribution, but you remember that the bankruptcy judge has this ability to oversee and police the process. And a question, at least, that I would urge people to start with is to ask, is there an abusive process here? So let me just give, two quick examples and then open it up to people. For example, when it comes to critical vendor orders, I would resist the instinct to say, we can't do that, because all of a sudden we're paying off a pre-petition creditor, and the decisive thing is always whether it's a pre-petition creditor, and if it is, it's bad, or at least we should feel embarrassed about it, or something like that. I would suggest that critical vendor orders come in at least two different flavors. One flavor is it's just good business. You're spending money to get something you don't otherwise have the right to. For example, honoring frequent flyer miles, honoring warranties. Those are situations where you are basically honoring pre-petition obligations in full, and you're doing it because it's good business. And what's decisive about that is these scattered holders of warranties and so forth, they're not strategic players in the bankruptcy process. They're not trying to game the system. They're not trying to behave strategically. There's no gaming of the system. My favorite example here is in the Marvel Entertainment bankruptcy. There was a question of whether to ship goods to customers who had prepaid for the goods, and a decision was made that they're going to continue to ship product to prepaying customers, and these prepaying customers, they were just general creditors, and they said, we think in this case it's good business. Okay, well, why is it good business? Well, this is Marvel Comics. You know, you don't want 200,000 12-year-olds, you know, noticed up in your courtroom, you know, demanding to be paid and so forth. It just wouldn't make sense. But again, it was just good business. That kind of critical vendor order is quite different because of these process concerns than a large amounts of money going to players who are active in the case. Let me give another example. This emphasizes the lack of statutory hooks.
Douglas, you say critical vendors, but it turns out that all the examples you're giving are critical customers, not vendors.
Okay.
So, but we use the shorthand critical vendors.
Right, okay, but they're still pre-petition creditors.
Yes.
And you agree you wouldn't require the 12-year-olds to come in to court?
I don't know, you know, maybe we'll
Maybe,
think about it.
maybe you just snap your fingers.
At any rate, I would,
See who saw the movie.
Shazam.
Yeah.
I would, oh, right, I'm not into this. Okay, let me give another example of where we lack statutory hooks because we didn't foresee going concern sales. Let's say, so let me give the following situation. We have a business and we decide to reorganize it, and the business doesn't have enough value to pay the secured creditors in full. There's a plan of reorganization, and under the plan of reorganization, the secured creditors get the company, the general creditors get nothing, and something goes to the old owner-manager CEO. Okay, we all understand the way we think through that problem is 1129B, the fair and equitable test, the gifting rule, and all sorts of stuff like this. Well, we can have a similar, but you don't want to say that's the only thing that matters is 1129B2, because you can have the same kind of problem arise when, let's say, we have a sale, and it's going to be a sale, and the secured creditor is going to credit bid, and the secured creditor discloses that you know, if it does in fact become the high bidder for the firm, it has already entered into a contract with the existing CEO, who in this variation is not an old shareholder, and is going to continue to employ that CEO in the business. So again, it's a 363B sale. What we have is a secured creditor who's going to credit bid, and the secured creditor has separately signed a contract with this CEO who was never part of the capital structure, never a shareholder. Well, how do we think about that? Well, we can't sort of talk about fair and equitable and 1129B and all this other stuff because none of that's happening here. There's no reorganization. We can't talk about class skipping because the CEO is never a shareholder in the first place. How do we start thinking about that? I don't think you can get into talk about distributions from the estate and so forth, but I think the more straightforward way to talk about this is just to actually ask, okay, what's going on here? You know, let me give you door number one and door number two. Door number one is what we have is a CEO who actually may not be very good at managing the business, but he knows the secret sauce. He knows the technology. I don't want to run this business unless I have this guy in place, and this guy ain't going to be here unless he has a piece of the action, and that's why I'm doing this. Okay, that's one kind of story, no abusive process. Second kind of story is what I really want to have the CEO do is to be a strategic advisor. And I want him to think profoundly and deeply about strategic advice for the firm going forward. And the way in which I want him to do this is to move to Florida, throw away his cell phone, play golf, think strategically, and if I need his advice, I'll call him up. And, you know, that strikes me as a different type of problem. And the way to think about that problem is to think about this from this fraudulent conveyance perspective, this emphasis on process, rather than looking for statutory hooks that might not be there.
So Douglas, just one question. The title of your piece had the words unwritten law of corporation.
Right.
What's unwritten?
Well, I mean, I think here we can get into a metaphysical discussion of to what extent are these lessons embedded in the common law.
I ask it just because I'm a jerk sometimes, but I'm also asking it. I'm also asking it because I think it's important to your process or to your position in terms of these. And you kind of said at the end, don't just look to the statute.
Right.
There are other norms, there are other expectations, there are other understandings that need to be consulted. And I'm just trying to understand how you work that into the structure that you put up.
No, I think the common understanding emerges from, among other things, judicial opinions. But as we know, we can have some appellate court opinions that sometimes, aren't terribly helpful and sometimes appear to say the opposite of what we think they are. A case like Lionel is a case that turns down a going concern sale, but everyone cites that case to say it's a sale going forward. We have some cases where we look at them and, everyone knows they just aren't right. We have other situations where people will refer to things as opinions when in fact they're just observations a court made from a bench. For example, for years in talking about restructuring support agreements, everyone worried about Judge Walrath's opinion in Station Holdings. Well, there's no opinion, there's just a comment from the bench that everybody happened to know about. So all these things are part of this background. And again, it's not necessarily a healthy thing that a lot of this is wisdom that we share, that if you are simply someone from Mars or a law student is not going to have ready access to.
Can I jump in and ask a question too, following?
You can say things, you don't just need to.
All I could say is, I'll ask a question that is saying something. So let me start it as a comment. In many respects, this is a paper about judges and the role of judges, at least as one of the purveyors of these unwritten rules. And it seems to me that the idea you have about the role judges play today would have been appalling to the New Deal reformers. They didn't have my understanding of the New Deal reformers from the research I've done is they wanted judges to pierce through these unwritten rules and to get rid of them. Right. Whereas you seem to have an idea that from the beginning the judges were part of this and they are effectuating the unwritten rules. Could you say something about that?
Back up a second. Can you explain and unpack what you mean about pierce through the unwritten rules? What do the New Dealers want the judges to do?
Sure. So in the early 20th century, equity receivership ran very much, and large-scale corporate reorganization worked very much the way Douglas describes. It was Wall Street bankers and lawyers
And my partners.
And your
partners. Your partners were the key player. Your former partners were the key players in this. When a railroad failed, they would put together committees. The committees would negotiate with each other. They would pretend to do a foreclosure sale of the railroad. The foreclosure sale was actually a sham sale. It was a reorganization of...
You say sham in such a critical way.
Because I have...
Say it's a virtual sale.
It was a put up to go for fairness, right? The idea was that you set a price, an opening price that nobody but those who could credit could meet, but because it was open to all, it was fair. I mean, in that sense, it was a sham.
In that sense, it was fair.
Yes.
It was or wasn't, but
It's like a thaumatrope.
The first few decades of the 20th century, that's the way large-scale reorganization was done. In the New Deal, well, it was codified finally after decades of just being common law. It was codified in 1933 and 1934. New Dealers like William Douglas and Jerome Frank came in. They were appalled by the system. They thought it was insiders helping themselves, that Rich's former partners were making themselves rich, and they were buying houses at cottages at Newport and Long Island and places like that. And this needed to be brought to an end, and the way it would be brought to an end is bankruptcy would be reformed as it was in 1938. And a judge would come in who in the large-scale cases was not the bankruptcy judge then called a referee, it tended to be a district court judge, and would see through all of this. So one way of telling this story would be the New Deal ended the unwritten rules, and the unwritten rules have crept back in. Is that consistent with your story, or are you telling
No, I think it's more complicated. Again, the New Deal, did catastrophic damage to the old traditional practice. The crevasse of this world left the reorganization world. They were excluded because if you represented an investment bank that was involved with raising capital for the company, you couldn't also be involved in its reorganization. And the glue that made these things work was not the kindness of these investment bankers or their lawyers, but rather the fact that they had to repeatedly go back to the credit markets, and the norms they established among themselves were norms that were observed. No, I think the story that happened is that the Chandler Act was an alliance between the New Deal reformers on the one hand and the National Association of Credit Managers, the lawyers who at that time constituted the National Bankruptcy Conference, the lawyers who did the small reorganizations and restructurings of let's say, retailers whose credit largely came from their suppliers. And that was old Chapter XI. And there we did see this continuation of these norms and practices and so forth. And I think
if from the same mouth that you hear the word sham, you might also hear the word bankruptcy ring.
They're definitely, one of the things the Chandler Act was trying to do is to clamp down on the bankruptcy rings that emerged in the 1920s. But the people behind the Chandler Act were parties who were quite hostile to these bankruptcy rings. And again, there were a lot of unattractive features of bankruptcy practice before 1970, and there were a number of jurisdictions, not least of which was Chicago, where there really were bankruptcy rings and the bankruptcy practice wasn't right. Nevertheless, there were other parts of the country, and I think of the West Coast in this connection, where you did have effective processes and effective negotiations and effective norms among able lawyers and referees that did allow this process to continue, and we did have successfully reorganizations of these smaller firms.
Right, and you had, from the West Coast, which is not the greatest, you had Case versus Los Angeles Lumber, right? I mean, that case says that the fair and equitable language meant and incorporated kind of what it meant in equity receiverships, right?
I'm not sure we want to talk about Los Angeles. No, but that was a 77B case, and that was a William O. Douglas opinion that put us on the wrong track. For
No pun intended.
Yeah.
Right. Yeah. And
I mean, if you look at the statutory evolution, before you get to 77B, fair and equitable didn't appear in the statute together. It appeared first as fair, and then later, 2 years later, they added the words and equitable. And although cases can be looked at a lot of different ways, it does kind of say, listen, we're just going to, those words mean kind of what absolute priority meant before we tinkered.
Well, the words absolute priority had never appeared in any judicial opinion before Case versus Los Angeles Lumber Product.
And they don't appear either in the Chandler Act or in the Bankruptcy Code.
Right.
And so the question is, what were the practices that Justice Douglas is invoking? And in fact, the opinion certainly says there is this pre-established practice, but I think the history there is much more controversial. And again, you can read a number of the opinions that Justice Douglas cites as embodying absolute priority, and they just don't. And he also knew better. He was a professor.
He started at Cravath.
I know. Yeah, he washed out. And he taught corporate reorganizations at Yale, and he's citing these cases, and he really should know better. So I think there's a very complicated story there. But when I'm tracing the arc of small companies, I'm not talking about the Los Angeles Lumber, which is a very substantial shipyard during this period. But Los Angeles Lumber
actually returned a lot of money to people because of the war effort.
Well, it actually failed during the war because, remember, it couldn't successfully reorganize because of Douglas's opinion. That Douglas's opinion, remember, under old Chapter X, any individual senior creditor could gum up the works by saying, I'm not being paid in full. So in Los Angeles Lumber, there were exactly 2 guys who weren't paid in full, and they gummed up the entire works. And indeed, it was so bad that the workers at the shipyard passed around the hat to get the money to pay these creditors off in full. And they fell a little bit short, and the creditors refused to take it. And ultimately, this is a shipyard during the middle of the Second World War that couldn't make a go of it. It was taken over by Todd Shipyards.
Yeah.
Yeah.
Well, I mean, I can drop Case and go to a larger point. I mean, it maybe take a little bit different divergence if you allow me.
You should see the copious notes he's been taking.
They say something about you here too, but I'm not going to go into that. I mean, obviously, just for the panel, we all know each other very well. I think we all kind of go back at least, 20 or 30 years. So a lot of what you see here is our debates and snippets of debates we've had before. One thing that I think Douglas has right, but I'm not sure he pushes it in the right direction, is this notion that when new things come up, look beyond the statute. I'm not sure that the word statute there is really, were I to write this, and I'm not, but what I would put there. I mean, fraudulent transfer law or fraudulent conveyance law, however you want to call it, or avoidable transactions as they butchered it in the latest iteration, has always been not really kind of statutory law, but kind of the law of doing things right. I mean, if you go back and you take a look at it historically, Twine's case may have crystallized and refocused it, but people were talking about badges of fraud and people were talking about transactions that harmed creditors long before 1600 and before that. And even if you look at the modern kind of versions of it, I mean, our current law with respect to restrictions on corporate dividends, the modern law to the extent it still exists on bulk sales, were also offshoots of how courts viewed fraudulent conveyance law. And I think one of the things that happen is that, people say that water, conforms to the shape of its vessel. In one sense, fraudulent conveyance law is just kind of a proxy for, strangely enough and unhelpfully, I think, doing things right.
Based on the standards of the day,
Right.
and what commercial morality is at any given time.
Right, and that becomes a really troublesome issue when you say, okay, look beyond the statute that we have and, go back to what fraudulent transfer law is. I'm not sure that that was a stable target throughout the time period that you're talking about and before. And so I'm not sure that it tells us how to kind of react to some of these new devices, the new constellations of power, the new incentives that we see. I mean, I think you could use fraudulent conveyance law to do that, but I don't think you'd be looking to the way in which lawyers and judges were looking at it in the 20s, the 30s, the 40s, or even the 50s.
And although I like your jumping off point of fraudulent transfer law as the basis for the railroad, the limitations in the railroad reorganization cases, Howard, and then up through Boyd, the hypothetical you gave really has nothing to do with fraudulent transfer law.
Which hypothetical?
The paying off the CEO, because neither involves a debtor making payments to a relative, a creditor, or anybody else that it owes any obligation to. It really has to, you've expanded the concept of fraudulent transfer law to go one step further, to pick up on Bruce's point, and say, does it violate some other commercial norm, which is you don't pay bribes to get this kind of stuff done?
No, again, I understand that, traditional fraudulent conveyance law requires discrete transfers and so forth. The larger point I'm making is
That's what I was going at, yeah.
No, but I'm saying if you go back to the late 18th and early 19th century, you see courts specifically invoking the statute of 13 Elizabeth. They're specifically invoking fraudulent conveyance doctrine, and they're doing it in transactions where they're not looking at a specific bad transfer by a debtor, but rather they're looking at a particular process, such as a foreclosure or some other judicial action, judicially supervised action, and they're using the language of fraudulent conveyance law as the entry point into asking whether or not these transactions were regular. So to go back to...
I would argue that in those railroad reorganization cases, they actually were looking at transfers from the property of the railroad to the old shareholders, and that rubric, fraudulent transfer rubric, fits that kind of a transaction. And I agree with you that they said this might just smell bad, but I think they were technical enough lawyers and judges to frame it in those terms, and it fit.
Well, and I actually, I agree with almost everything Douglas says, except I'm not sure it's the judges who invoked the fraudulent transfer law. I think, if anything, you may give too little credit to the lawyers and investment bankers, because to the extent that I think there are unwritten laws or that there are practices, I think they get developed from the lawyer's side and presented to the judges, because I think sometimes, truth be known, and I said this in the paper, sometimes lawyers look at judges as roadblocks rather than as entities that will facilitate the process. And I've tried never to underestimate the creativity and the cleverness of lawyers in taking existing doctrine and molding it to their needs. And I think what we see in the 19th century, or at least what I see, is the rise of limited liability and the rise of large enterprises that limited liability permitted. I mean, you don't really have kind of the corporate form until the middle of the 19th century. The rise of the large form, the rise of large financial errors that I think something like half of all railroads had gone through some form of restructuring by 1915. What you have when you have all of that are new problems. And what lawyers do and what lawyers can do is to try and go to judge and say, well, here's this theory, Your Honor, that I think makes my client win. And I think rather than, judges, activist judges may kind of take that and go beyond that in opinions. I'm certainly not going to discount that. But the word I would change is invoke. I think the judges may have passed on what lawyers kind of put before them and maybe developed it more, but I think the progenitor of this is not some type of union between the lawyers and the judges, but the cleverness of lawyers or the desperation of lawyers to try and get a ruling from a judge that their client prevails.
I want to give you two thoughts on that, and I'm going to give one of them to somebody who was a former judge, so he might well disagree with me on this, but from my perspective of observing judges, first, the first point not related to judges is that creativity of the lawyers in taking existing principles and molding them to current realities is what has kept the Bankruptcy Code alive for 40 years, alive and relevant, sorry to the consumer guys, at least on the business side, it's still very relevant to corporate reorganizations, despite the dramatic changes in the financial markets and the economy that has occurred since the code was enacted against a very different economic and financial world than we have today, and yet it still works. So that creativity is actually a good thing. It makes the whole system function, and in my view, is one of the strengths of the common law versus the civil law jurisdictions.
I agree, actually, with that.
Okay, on the judging point, yeah, it's the lawyers who came up with these ideas, but my view of judging, and it's probably because I went to a law school where they used to teach legal realism, my view of judging, it's what I summarize is it's what the judge had for breakfast. Judges have an inherent perspective on the world, formed by the statute and the case law and the common law, but also formed by the culture that they live in and they grew up in and they were trained in. And when a case comes before a judge and they hear the facts, they're going to mold the statute or the interpretation of the law to fit the facts that they hear and their reaction to the facts. And what I read in those cases that you're talking about, fraudulent transfer, yeah, the lawyers brought the judge's stuff. It wasn't my former partners, sorry, Victor Morowitz, and, he was successful, but the ones where he wasn't successful was the judges saying, this just doesn't sit right with me. I know you're like, technically you got this, but it doesn't sit right with me, and and that's what happened with, I think, Douglas in the Los Angeles lumber case. I don't agree with it as a matter of principle, and I'm gonna mold it. Now, I had the good fortune on my way here last night to read an article that I had plucked out some years ago and been sitting on my desk, written by Jerome Frank, one of these new dealers, in 1948 in the Columbia Law Review. It's called, and I just sent a copy to Douglas, I commended it to him, and I'll commend it to all of you. It's not very long. It's called Words and Music, a note on interpretation of statutes. And he makes the point that as a conductor interprets a composer's music and does not play it literally, it's based on what the conductor understands and feels, and so judges are with respect to statutes. And I think that's what explains what was happening in the late 19th, early 20th century in these matters, and in the New Deal as well.
No, I should also say that if we look at the dynamics, the investment bankers and the lawyers that David in his book gives so much credit to shaping the law of corporate reorganizations, they're the people who were pushing back against the fraudulent conveyance characterization. And the person who put forward the characterization were the lawyers representing, let's say, Boyd, who was just but he was just a dinky trade creditor. He wasn't sort of
Well, he was more than dinky. I mean, he took 20 years to pursue his claim.
Yeah. Okay, he was a
Stayed at it.
He was a persistent dinky creditor.
persistent trade creditor. So it's I should also say that judging, like anything else, can be done well or done poorly. And I would say
So can conducting.
And one characteristic I would note of what able bankruptcy judges do is not simply ruling correctly on the law, but also just having a feel for when they should rule, when they shouldn't rule, when they should delay, when parties, if they're set out into the hall, are going to reach a deal, and when, in order for the parties to reach a deal, the judge needs to make a decision on the merits.
All right, so great jumping off to Jevick. Okay? Jevick decided at the bankruptcy level by one of the best bankruptcy judges out there.
Absolutely.
Top notch. And he decided.
Give a shout out, give a name.
Brendan Shannon.
Brendan Shannon.
Brendan Shannon.
And are you going to describe the case?
Oh, everybody knows what Jevick is. All right, I'll describe the case. Secured creditor, who was also the equity owner of the debtor, advanced a lot of money, and there was a second secured creditor. There were some unsecureds, and there were employees who had been fired and not given their 60-day WARN Act notice. And they were suing, they had a claim, an allowed claim against the company, which would have been priority under 507A for their WARN Act severance, priority claim. They were also suing the secured creditor in its capacity as shareholder, claiming it was a control person and therefore was liable directly to the employees under the WARN Act. Right? Got it so far? There was an argument that the secured creditor was liable for fraudulent transfer in connection with the LBO in which this creditor, equity holder, private equity company, bought this transportation, Jevick Transportation. The fraudulent transfer claim was weak, but it could be brought, and there was a chance of success.
It had settlement value.
It had settlement value, at least settlement value. The secured creditor was willing to settle the dispute, but didn't want to pay the money to the estate because going down the waterfall, it would pay administrative claims, and then it would have paid the WARN Act creditors, the union, and it would have helped the union fund its action against the secured creditor for the WARN Act liability.
And something I should say here, this isn't Rich speculating about motivations. The secured creditor said this in open court.
On the record.
On the record. That the reason I'm doing this, Your Honor, is I don't want to fund litigation against me. I'm only going to settle if the money doesn't go to them. I'm not going to do it otherwise.
So
Not unreasonable. Yeah. I mean, I don't want to pay people who are going to sue me with it.
So the creditors committee and the secured lender and the other secured lender get together and they make a deal. The secured lender kicks in $2 million in settlement of the fraudulent transfer litigation, gets full releases, and the administrative claims get paid and the unsecureds get paid, and we skip over the medium priority class, the WARN Act creditors. Judge Shannon, being a very practical and thoughtful judge, says, boy, this is a tough case. If I don't approve this settlement, nobody gets nothing. If I do approve it, at least the administrative claims get paid and the unsecureds get something, and I'm sorry the WARN Act creditors don't get anything, but $2 million is better than nothing.
And the WARN Act claimants aren't any worse off because they
No worse off. They're no worse off. So reluctantly, I will approve this. Goes up to the Third Circuit. The Third Circuit says, really bad case. Hard cases make bad law, and we don't expect to approve this kind of thing very often. It's really bad, and this is a really unusual situation. It's unique. We'll approve it this time, but don't get in the habit of doing this kind of stuff. And there's a dissent that says, in effect, the judge could have insisted on more bargaining so that the Warren Act guys would have gotten something. They could have been at the table and given them something and settled this whole thing out. Not a good deal. Skips over the priority, disregards the code's priority, should not be approved. Goes up to the Supreme Court. The Supreme Court says, pretty much agrees with the dissent. Priority is the most important thing. There are certain circumstances where you will pay off outside of priorities because it enhances the overall value of the estate, and cites critical vendor orders as an example of that. It says, but this one's bad, and
Even though it does enhance the overall value of the estate?
even though it does enhance the not the value of the estate, but the recoveries to various creditor groups, and the Warren Act claimants are no worse off. And by this time, by the way, which might have influenced the decision, the Warren Act creditors had lost final order in their lawsuit against the private equity sponsor. They were out. But the Supreme Court says they should have a seat at the bargaining table, and therefore this settlement should not have been approved, and overrules Judge Sanders. So now, where did we start on this one?
No, but you're speaking Douglas's language.
I think it's interesting that Judge Shannon's reaction after the case was decided and after he got reversed unanimously by the Supreme Court is he actually didn't feel bad because he actually likes the idea that his hands are tied going forward.
Yeah. So bankruptcy judges, they try to be practical and apply these kind of unwritten rules, but lo and behold, the written rules come back to haunt them. Then the Third Circuit decides the ICL case, which was actually before Jevick, right?
No, it's decided, I think it was decided before the Supreme Court case.
Before the Supreme Court, after the
Third Circuit, but before. So.
There, similar facts, they skipped over the administrative priority tax creditor for the capital gains upon the sale. And the Third Circuit approves that transaction. Yeah, so that one was, and the reason they approved it was really weird. The secured creditor credit bid his claim for all of the assets of the estate, including the cash in the estate, and then took its own cash, not the cash from the estate, because you can really distinguish which is which, right? Took its own cash and funded an escrow to pay the administrative claimants except for the government's tax claim and some unsecured creditors.
It was its own money.
It was its own money. Third Circuit said, well, it wasn't the cash of the estate it used its own cash, and therefore it was okay.
And what I think is bad about that opinion, though Rich doesn't see it this way, is that getting your hands tied about whether it is or is not money of the estate is neither here nor there. I mean, here we have a secured creditor who's paying off the creditors committee and other people to look the other way, and that's something that the judge should police against. Now, again, you can defend the case, I suppose, weakly by saying the bankruptcy judge, and looking at the overall transaction, blah 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 blah, didn't abuse its discretion. But it's a case that makes everyone uneasy. But the reason it makes me uneasy is that there's a process failure that isn't being policed, not that there happens to be money coming from the estate or not.
Yeah, so
But they're using the estate metaphor as the proxy for what you're concerned about.
No,
the question is whether that's a good fit.
They failed to do that.
They failed to do that. They should have. But the process point was, in effect, the government should have been given a seat at the table for those negotiations. Yes. Fine. But what happens if they couldn't make a deal?
Yeah, if they're given a seat at the table and they're ignored, it's the same thing.
Boyd, what's the quote from Boyd?
Don't put him on the spot like that.
Which it's a long opinion.
Let's bring it back around for just a minute and assume for purposes of our discussion.
The quote from Boyd is, if the creditor has made a fair offer and he refuses it,
that's his
too bad.
Yeah.
That's not an exact quote.
No,
It's close. It's a 21st century version
I
of
think
it.
it's time for adult supervision.
For just a moment, assume, and we had a little debate earlier about whether there really are any unwritten rules, but let's assume for this portion that there are a set of unwritten rules about bankruptcy. let's assume that they're bounded only by the creativity of the lawyers involved. Address a couple of things, each of you. One is, look, the obvious upside is we could get the results that we want bounded only by our own creativity. But what do you think the downside of having unwritten rules are? And also for the aspiring young lawyers in the audience, how is it that we're supposed to figure out what the unwritten rules are? How do you learn bankruptcy if it's not going to the code and going to the cases? How do you equip yourself to participate in a process where the rules are unknown?
I think it's hardest with respect to things like restructuring support agreements. I was asked to write an article on restructuring support agreements, so the first thing I did is go to Westlaw and do a search for law review articles that talked about restructuring support agreements. This is like in 2015, and it came up with 0 hits. If they're new practices, it's hard to know what rules govern them unless you're something of an insider. I think the big dangers and the big downsides are the way in which people can get used to practices that really are rather suspect. I think my current poster child for very suspect reasoning is Peabody Energy, where this is a case from the it's a decision from the Eighth Circuit, in which what you had is a small group of hedge funds negotiate with the debtor at the start of the case, and the bargaining is limited to this particular group. Now there's another hedge fund that could petition the court, and if they did agree not to sell their shares, if they did agree to non-disclosure agreement, if they did agree to other conditions that aren't specified, they might have been able to participate as well. But they are frozen out of these negotiations, and there are a set of negotiations, and in these negotiations, the large hedge fund agrees to support a plan, but at the same time, they get equity at a huge discount to value. And this plan, they sign this agreement, this plan goes forward, and the question ultimately is, does it violate the equal distribution rule, and also is it otherwise something the bankruptcy judge can approve when you have one group of a particular class of creditors getting an opportunity to get equity at a discounted price, and they all wanted equity for a variety of different reasons. So you have one group. No, but this is metallurgical coal rather than thermal coal, and so this is at a time when actually the value of the firm had gone suddenly up. So it was actually attractive to want to be into this firm. And these people, this hedge fund got a special deal, and the question is, should you be able to get a special deal because you sign on board to a plan early when other people didn't? Now again, one of the things Rich will say is that the small.
What my former partner said.
Yeah, one of the things Rich will say is, the hedge fund that was excluded, well, they could have signed on, they could have done it, and at any rate, they were grown-ups anyway, and everything was fully disclosed, and so forth. But still, I think this has to make you feel somewhat uneasy.
It does.
And I think there's a range of things you can say here. I think that it's possible to say, no, we're just not going to allow these kinds of deals. I think some judges that I've talked to take that position. Other judges take the position and say, look, if these are sophisticated guys, if it's fully disclosed to the court, if they, if it really helped move the plan forward, I'll let this kind of thing happen as long as I'm made aware of everything and everything is disclosed. And that's contestable. I think that what's not contestable is that if instead of a small hedge fund, we had dispersed small investors who weren't active in the case, and they were the people who were shut out, I think we would all say, no, that's no good.
That actually happens a lot because these rights offering is what you're talking about, are sometimes available only to qualified institutional investors, QI participants, I forget what they call it, QIPs. And so the small guys who own bonds can't share.
Which is exactly the opposite of what Douglas wanted under the Trust Indenture Act.
And we argued in '78, we were arguing with the SEC. The SEC still had this 1938 mindset. The guy who was the head of that division of the SEC at the time was actually a new dealer and had been there in the 30s when Chandler Act was written.
There's Aaron Levy?
Aaron Levy, yeah. And he had that mindset of protecting the small investors, and we said to him, no, you don't understand. The small investors in bonds that were there in the 20s and 30s, no, they're now stockholders. And if you want to enforce the absolute priority rule, you're going to give it to the big investors who are in the bonds, and you're going to wipe out the small guys who are all now stockholders. And he never accepted that. Still held to the absolute priority rule.
So I have a couple of questions coming out of this for Douglas, related questions. One is, how do you draw the line between Peabody, which is a case that I think all of us are uncomfortable with, and the run-of-the-mill RSA that has some sort of fee for the signatories? What is not okay and what's okay? And the second question that's related to it is, do you think that judges have the tools they need to be making these distinctions, or is there something more judges need to be playing the kind of role? I mean, you have this argument that judges really are going to be able to sort out the good eggs from the bad eggs. Do they need anything else to do it?
Well, again, I think the law on RSAs is still evolving. I mean, one of the embarrassments we have is that the question here is post-petition, to what extent can you solicit someone to support a plan before there's been a plan and a disclosure statement that's been approved by a judge? In other words, to what extent can I solicit your vote and get a binding commitment from you to support a particular plan if the particular plan in question hasn't been presented to a court and a disclosure statement hasn't been approved? Well, what modern bankruptcy judges wrestle with are the conditions under which this can happen. Okay, now, part of the problem is that we already have a statutory answer in 1125, and 1125 appears to say you just can't do it. And so, you know, all of us feel a little bit dirty because we know that that's what happens anyway. To the extent I've seen various practices emerge.
You don't feel dirty, Douglas. It's okay.
Well, you're academics. I mean, you don't get a chance to anyway.
But
Not in Puerto Rico.
Yeah, well,
Or PG&E.
in Puerto Rico, well, never mind about Puerto Rico. I won't talk about Puerto Rico, but the
You can if you want.
the typical. I think one of the practices that's emerged that I suppose I feel somewhat better about, though again I feel, uneasy given we have 1125, is what courts seem to bless especially are these RSAs that emerge from mediation, and very often it's mediation supervised by another judge.
Yeah, let me go back to something you just said a moment ago at the beginning of that. What you feel uneasy about and what you feel comfortable about, I think underscores my point about how we all approach these things, judges included. We have a kind of a worldview of what's fair and what's not fair, and then we interpret the statute and the written rules and the case law and the principles to confirm our worldview. It's confirmation bias.
Why'd you put 1125 in there in the first place?
Well,
I mean, to answer Sarah's
I'll
question,
answer that if you want.
to answer one of Sarah's questions directly, what's the downside of unwritten rules? The downside is, I would say, you have to rethink how you select bankruptcy judges. You have to rethink your venue rules. Because there are 345, I think, or 346 authorized judgeships. There's maybe 7,500 Chapter 11s a year. They don't get distributed evenly. About 20% or 25% wind up either in New York, Delaware, or Texas. And if, in fact, you have judges who are not inculcated in these unwritten rules, you are going to get disparate results. Moreover, there is from the other side, if you will, and I won't name names for obvious reasons, but there are a lot of judges who are known to be result-oriented. And I will tell you from discussions I had when I sat on the bankruptcy appellate panel, sometimes when I would come out with a draft opinion, someone would call up and say, well, that's not right. And I said, okay, well, tell me where the analysis goes wrong. He says, I don't care about the analysis. That's just not the right result. And as long as you have that kind of viewpoint in it.
Throughout the judiciary, it's not just bankruptcy judges.
Well, but if you want to talk about unwritten rules in bankruptcy and making and facilitating the way people work and sorting the good from the bad, the fair from the unfair, and doing that against a background of what you know and what you've seen as a judge, you got to ask, well, do you want or do you not want kind of a pure judge who doesn't take into account these unwritten rules, or do you want someone who understands them? Again, go back to the point made in the keynote. You're going to lessen the diversity of the judges because most of the people in the reorganization world don't fit that. Again, the reorganization, that's where all the money is, but that's not where all the cases are. I mean, you really start talking about if you want to do it efficiently, maybe it's not a court-based system. I mean, because as Douglas pointed out before we all cut him off, you know, if you've got other mediators kind of coming in who are bankruptcy judges themselves, you have a very recursive system in which we all chase our tail, trying to impose the kind of notions that we had. I was very conscious as a judge. When I became a judge, I was 14 or 15 years out of practice. I was very conscious that the way in which I thought about things when I was in practice would probably be different the way when I was on the bench because time had passed. That was not a view that was universally shared.
By the way, the RSAs that get approved, I think a very small portion of them are negotiated with mediators. Many are just negotiated among the parties. They know the deal, and they all take their assigned positions and they argue about them and they come to a deal. I don't think.
No, and it's also interesting that they actually say the reason you should go with the plan judge is we have this RSA and it's regarded.
An RSA is usually done pre-petition, so there's no mediator.
Not
and a PSA, plan support agreement, is what's done post-petition and sometimes with mediation.
But it's the whole point of having the parties telling the judge, we've kind of decided stuff that really is, you know, we've all decided stuff, and because we've decided it, you should go along with what we say. I mean, I have this in the paper. I've heard law firm partners say something like, why should we be bound by someone who gets paid less than our worst associate? Right? I mean, because that's the way the system works. And who went to an inferior law school.
Judges are underpaid, that's why.
But it's, well, I'm not going to disagree with that, but, or that went to a lesser law school. I mean, there are lots of judges who just don't have the Chapter 11 background sitting on the bench. Some of them turn into great judges. Gene Weedoff's a good example.
But he went to a great law school.
He went to a great law, yeah, he did.
Martin
He did,
Martin
but he was not a bankruptcy practitioner when he was appointed, that's my point. He may not have known the unwritten rules when he took, I mean, he may have had all the capacity to learn them because he went to a great law school, but he didn't have the experience.
What law school was that, Douglas?
But he's no, but you know.
I mean, I guess my point is, there's a disconnect between the notion of unwritten rules and the notion of a judiciary that understands those rules the way it is currently set up. I mean, in no surprise that you find people gravitating towards certain districts where judges are perceived to at least know and adhere to some of those unwritten rules. But I think most people think that, unless they obviously often appear in those jurisdictions, don't like those venue rules. I was worried when I say something and no one says anything in response. It's like, how do we get on from that stupid point and go make something that makes sense?
Yeah, Doug, let's try to pick up a new comment right here. Do we have time for audience?
Yeah, we do. One more question, though, sort of if you kind of think about the bedrock principles of bankruptcy and in the discussion of fraudulent conveyance law, you really talked about, you know, equitable conduct and fairness to the parties. And I can remember being a young bankruptcy lawyer and really having it impressed upon me how, and you hit on this as well, transparency, the living in a fishbowl, the ability to participate. Judge Hagenow talked about it in her remarks, that, you know, how bankruptcy really does, it's the one sort of forum experience that so greatly affects almost everybody. How do you marry up sort of the bedrocks of transparency and participation against unwritten rules? It seems to me that those appear to be somewhat inconsistent, and should we acknowledge that or deal with it?
No, I think that's part of the awkwardness of this particular world is that especially because of the rules governing bankruptcy appeals, it's very often what any particular bankruptcy judge says is going to be effectively unrepealable in a case. Now, again, there's a new automatic stay opinion that might change things, but essentially in a world where refusing to confirm a plan of reorganization is not itself appealable, there is much less appellate oversight than you might think. I should say, though, in defense of these unwritten rules, one of the biggest unwritten rules is, even though there are various provisions of the Bankruptcy Code that require disclosure, as a lawyer, you are flirting with danger if you don't make full disclosure of stuff, and it's hardly a defense to say, well, gee, Your Honor, there's no specific rule that says I had to say this. I mean, that I think is asking for a lot of trouble.
I gotta finish before we go to the audience with asking you a question. So these unwritten rules, are you for having unwritten rules or against it?
Like most academics, it's complicated.
All right, and one last follow-on question, if I can, before we go to audience questions, and that is, the subject of mediation came up, and mediation has become much, much more central to many big cases. In the Puerto Rico case I'm involved in, mediation has been a very, very big part of the bankruptcy process. Does that facilitate your unwritten rules, or does it undermine your unwritten rules? And does it facilitate transparency or undermine it? Because in many ways, mediation is enormously non-transparent. I mean, the Detroit bankruptcy was completely non-transparent.
Yeah, the Detroit bankruptcy mediation was problematic.
Yeah.
Yeah.
Even in Puerto Rico, the mediation is entirely confidential.
Yeah.
Entirely.
Right. Though.
So they can talk about the unwritten rules openly.
It's,
The ones who are there.
The others don't
Mediation
count.
promote or cut against the unwritten rules?
Well, again, the mediation is another instantiation of this idea that parties have to find their own future, and it's not the judge's job to do that. One of the effects of these mediations is that because judges are themselves participating in these mediations, to some extent, they can tell the parties, look, this is what the lay of the land looks like. This is how the world looks to a bankruptcy judge. This is what's going on. So at least in that,
And sometimes they're right.
and that hermetic. Well, again, it's an unusual type of mediation in the sense you have Barbara Hauser, who's an extraordinary bankruptcy judge who's supervising it, and among the mediators is Tom Ambrose, who is a Third Circuit judge. So you have a bankruptcy judge supervising the mediation, and one of the people she's supervising is a Third Circuit judge, which is.
I will, just one small comment about mediation. I don't like mediation. I don't like mediation.
I'm with him.
No, when I say why, you probably won't be. The reason why I don't like mediation is my experience, and I've been asked to be a mediator in various cases. My experience is that most lawyers who participate in mediation will take me aside and say, I know my client's got a losing case, but I don't want to tell them because I don't want to lose them as a client. I want you as a mediator to tell them. And if that's the role of mediation, I don't think that's a good thing. I mean, if that's the unwritten rule of mediation, is that you can avoid responsibility of telling your client bad news, I don't like that unwritten rule.
That should at least give us one element of professionalism hour. How about from the audience? Any questions?
Dare you ask us any? Oh, come on.
Well done. Thank you.
Who are you? Oh, good, a student, so we'll go light on you. You don't know the unwritten rules yet?
How do you feel about commuting to New York?
Well, I think it's, again, I have, I'm probably an outlier on this panel. First, I don't think simply saying principal place of business is actually, going to solve the world's problems. We have the experience in Europe of trying to figure out where the center of main interest is. But take, for example, Boeing aircraft. No, I'm not saying you should fly on it, but if
Or this idea won't fly.
But where's it supposed to file? Okay.
Chicago or Seattle?
Or in Southwest, or in California. A lot of its defense business is located in Southern California. So it has huge manufacturing facilities. Its whole defense business is in Southern California. It does manufacturing in Seattle. It's corporate headquarters.
St. Louis presence as well?
Yeah.
Yeah, and its corporate headquarters are technically in Chicago. I mean, does it somehow all of a sudden make the world a fairer place if all the Boeing employees in Seattle have to fly to Chicago? It's complicated. Also, you know, I think they're trade-offs. I think they're the one of the things about the concentration of bankruptcy judges in Delaware and New York is they're experienced and they're predictable, and those things are inherently valuable, and simply you know, saying, okay, we're just going to have Chapter 11s everywhere, you still have to ask the question, how is a judge going to be able to handle first day motions and to know what can be done and what can't be done and what works and doesn't work? And
Give you an example about experience, something I was involved in some years ago now, probably close to 20 years ago. I filed a case in a non-New York, Delaware jurisdiction, and I filed the necessary first day papers to make sure the employees got paid, and asked for a first day hearing, and the judge said, I'll see you in 2 weeks. And I had to call back the clerk and say, well, you mean the employees have to go without paychecks for the next 2 weeks? Oh, okay, we'll see you next Tuesday. I mean, an experienced judge would not have had that gap.
It's an unwritten rule.
Yeah.
yeah, you always play employees on the first day.
I mean, I may surprise Douglas. I actually mostly agree with his position. I mean, I think the underlying general basis of the, although I like Elizabeth Warren a lot, I think the underlying basis of the venue proposal was to give people access to courts, and I think the train's left on that. With modern technology, if you do it right, people can participate from anywhere. Anyone who's done a Skype or a FaceTime call, you can, I mean, there is a certain marginal benefit to being present there, but there's also a negative benefit when you've got a courtroom packed with a lot of people who don't understand court procedure. I mean, one unwritten rule is that the judge can interrupt people, but people can't interrupt the judge, right?
And you know, city council meetings, you pack the room because they're politicians and they're supposed to respond. That doesn't work so well with judges.
Right.
I should also say that in jurisdictions like Southern District of New York and Delaware, they actually do grant lots of change of venue motions when.
Oh, yeah. It's about a 70 or 75% grant rate.
And for example,
When the change of venue motions are made. And I remember one of my colleagues asking Judge Drain, sits in Southern District, why are there so few changes of venue? He says, most people don't file motions to change venue.
and
When they're filed, we usually grant them.
no, in EFH, for example, which is an energy company in Texas, they file in Delaware, and they filed in Delaware only after they've already talked to the Texas regulators, already after the Texas regulators said, yes, we understand these are adults playing in a sandbox, it's not going to affect us, Delaware filing is okay. There was a change of venue motion, but it was from the indenture trustee in Wilmington who wanted to change the venue, and
Let me throw why I'm on the same side as everybody. I'm really surprised that Bruce is on this side too. But how about one of the bases for your filing decision is if any connected company at all has filed in that district, you can file. So the way I think General Motors, it was either General Motors or Chrysler.
General Motors, yeah.
General Motors filed in New York City because they had a dealership in Harlem. They have no real presence in New York City, but basically you can file anywhere you want to file. Is that okay? My prior is that you shouldn't be able to kind of make up.
Well, it actually turns out that General Motors had still, when it moved its headquarters from New York to Detroit, I don't know, 20 or 30 years ago, it left most of its finance function in New York.
That wasn't the basis for.
Well, but the finance function is what Chapter 11 is about.
I mean, you have to get some agreement as to why something should be in a particular place. If it's because of access to courts, I don't think it's much of a reason. If it's because of access to particular judges with particular experience, that we got to talk about, because I have real problems with the notion of, if you will, an elite corps or viewed as elite corps of judges without any congressional authorization having the right to determine the way in which law goes. I mean, that becomes an echo chamber, right? Because if you only look at Second Circuit opinions if you're in the Southern District, if you only look at Third District opinions if you're in Delaware, that means who cares about what the Ninth Circuit says about Chapter 11? That may be a case, I mean, you may not want to look, the Ninth Circuit's not particularly good, but it's a uniform federal law. And you have some real dislocations if, in fact, you want to say, well, there are going to be pockets of people who know what they're doing. Maybe you want to have, as some have said, and I don't necessarily support it, a national appellate panel of judges, however you want to make them Article III or not, much like the BAPs are, where you have kind of a specialized appeal court. I don't know. But before you start talking about venue, start talking about why you want to put venue in a particular place. Bankruptcy venue is different than litigation venue.
And let me, to answer your specific question about not wanting to live, and I was only partly joking when I said, do you want to commute to New York? I spent most of my years practicing in Los Angeles, not in New York. And what I found, starting in the 90s, was that it didn't matter what court the case was being heard in, all of the negotiations, which is 80 or 90% of what the case is about, took place in New York. The investment bankers are there, the law firms are there. That's where everything happens.
Just to put an underscore on that, I mean, I know serving as the fee examiner in the Pacific Gas and Electric case, something I wish I'd never taken. And one of the issues we had early was whether lawyers could bill for non-working travel. For the first 3 months of the case, that turned out to be a multi-million-dollar issue. That is to say, lawyers were billing time traveling, and the worth of the time that they billed in the first 3 months exceeded $2 million. For just sitting
Traveling from New York to San Francisco.
Right, from just sitting on airplanes.
And by the way, for those of us who, at least one point in my career, traveled an awful lot, the phrase non-working travel is an oxymoron.
Yeah, I was about to say, I think we can close with the rule that the unwritten rule or written rule, there is no non-working travel. There is only working travel. It just depends on what client you're working for. Thank you so much to the audience. We appreciate it. To the panel, fabulous job.
Right.
You know what my proposal was?
No.
All right, everyone, that concludes this year's symposium. You are welcome to join us for lunch out in Hunter Atrium just through the doors. We will have Chipotle catering it, and we've got several drinks available, alcoholic and non-alcoholic, so feel free to partake. And thank you again for coming. We'll see you next year.
The plans-